that they have the knowledge and, I'm sorry, I can't read I can't read anymore with my 48-year-old eyes. I apologize, everyone. Knowledge and permission or acquiescence of USCIS. What acquiescence means is that the agency has agreed either by default or by not taking action to remove that person or deport that person. New York State Department of Health will recognize that that person is here as a proof-call immigrant and consequently eligible for Medicaid. So remember when I talked about there's two areas of law that dictate what happens here. USCIS, if you go to the next slide, the federal government is never going to tell an immigrant they're a proof-call immigrant. They're never going to get a lawful permanent resident card with a code that links up to some definition of proof-call immigrant. They're not going to get an employment authorization card that says you're a proof-call immigrant with a code that links to proof-call immigrant, because the proof-call status is linked to New York State, the New York State Benefit Agency, which in this case is the New York State Department of Health. Okay? So what does the last standard mean, the acquiescence, right, or the, I'm sorry, knowledge and permission or acquiescence? What we look for there is that the individual has properly filed paperwork with the USCIS to remain here, and that USCIS has acknowledged that filing. The State Department of Health, in writing, says that they will agree, that they will even accept the return receipt requested postcard and a copy of what was filed as acknowledgement. They're not even looking necessarily for a notice of action, which is the formal notice that you would get, or notice of receipt that you would get from USCIS. Okay, so do I have any questions here before we go on? Ayaz?
So this, I remember once told us that who called, if not when you get your green card, they said before, when you apply for a green card, you're protocol. Because we were getting cases of senior citizens who migrate because of their kids.
Okay.
They come in, and then they are legal on a tourist visa, but then they start changing their status. And I was worried whether that makes them eligible for Medicaid, and they said yes.
So I hope everyone heard Ayaz's question, and then Katie commented this is consistent with what I just said. And it is consistent because what that applicant can show is that they have filed for adjustment of status. They've already been admitted, and they've then applied, they've been admitted legally under the visa. The child has petitioned, has some permanent ability to reside here, and they can show that it was received, that it's being processed,
and that's
right? It's proof-call, right? That person is not a lawful permanent resident. They have a properly filed petition for adjustment of status that has been received by USCIS, and they've proved it either by the green postcard or the cancel check. Okay? We have some examples towards the end which sort of review this. Other questions about this stuff? Okay, so I'm going to move on. I think I'm going to go on. So who's the DACA? What are the DACA applicants? I'm sure everyone who has anything to do or has worked with young people and immigrant communities knows about the DREAM Act. The DREAM Act, you know, mixed reviews in terms of how far it went in terms of protecting young people that entered this country, not necessarily of their own free will. But here we go. The DACA rules were issued in July, and DACA stands for Deferred Action for Childhood Applicants. I'm sorry, I realized I should have spelled that out in the slide. So again, Deferred Action for Childhood Applicants. Everyone uses the acronym DACA. There's a number of eligibility requirements here for these young people to be able to apply to USCIS for the status. I'm going to run through it really quickly. I am not an expert on this. I don't know if anyone from Make the Road is on, because I know you guys have been signing a bunch of people up. So if I get something wrong in terms of the eligibility, I invite you to jump in and clarify, okay? But so basically, this is only available for young people. When they apply now, they have to be between the ages of 15 and 30. That's their current age. They have to have entered the United States before they turn 16, and they have to be under the age of 31 as of June 6th, I'm sorry, I can't see the slide all the way, June 16th, 2012. 2012, right, June 15, 2012. They have to have resided in the United States for that period of time. Okay, they can't have left this country. Okay, they have to have entered without inspection before June 15, 2012, or their immigration status has to have expired as of June 15, 2012. What's the difference? The first one's obvious. You cross the border, you use someone else's papers. Immigration status expiring refers to what I said before, which is someone who has some basis to enter legally as a non-immigrant and their visa expires. The visitor, the tourist, the student. Okay? You have to have not been convicted of a felony or have any kind of significant criminal record, and you have to currently be enrolled in school, or graduated from high school, or have a GED, or have been honorably discharged from the U.S. Armed Forces or Coast Guard. Now, these young people are eligible for Medicaid and the related programs, so Family Health Plus, breast and cervical cancer, the Family Planning Benefit Program, all of those. They're related under the PRUCAL category. Now, I'm sure those of you who are close to this issue have been following the news because the federal government did issue a clarification on August 30th, 2012, saying that these young people were going to be excluded from the definition of lawfully present for the purposes of the bridge plan, for the purposes of CHIP. But remember, we're talking about two different categories of law that create eligibility for Medicaid for immigrants. And these young people are eligible for Medicaid and the related programs in New York State pursuant to New York State PRUCAL analysis. I've confirmed this with the City Department of Health, and I've also confirmed this with the New York State Department of Health. I asked the folks, the new immigrant eligibility specialist at the New York State Department of Health just this week, when are we going to get something in writing? And she said, you're not, because we're in the process of updating our immigrant desk guide. They call it the alien desk guide, but I'm offended by that, so I call it the immigrant desk guide. And we have a flyer that Legal Aid put out that talks about public health insurance and these young people. So I'm going to take a pause here and see if there's any questions regarding this issue before we move on. Katie.
Can you just repeat it's Bridge and what other program that the federal government?
Child Health Plus.
Oh,
but that's outside of New York State, right? Because remember, in New York State, in CHIP, we cover all of our kids. We're going to cover our undocumented kids, our DACA kids too. And so I think this is one of the things that's confusing. I think even on the New York Times, they were talking about the limitation of some of the changes because immigrants in this state aren't going to be included, but they don't know the Medicaid rules well enough. If the person meets PRUCAL eligibility, they are going to remain eligible. That is not going to change for the Medicaid and the other public health insurance programs. Those programs that are 100% subsidized by the federal government, including stuff that's going to come through the exchange, that's next week's fight for all of us, okay, to make sure that more people are included than currently is contemplated in the federal rules. Okay? Anyone else? Anyone abroad or afar or from their desks that have questions? Yes. Someone's asking if I can go over CHIP. We're going to go over CHIP a little bit later in the presentation, and if I don't get everything you need to know, then please jump in and ask a question. Okay? Thank you. Lenka? Lenika. Thank you, Lenika. Okay. So moving on. So I have this slide, right? It's not January 12, 2010. Why are we talking about this? The reason I mention this is that this was the last group of individuals that came into PRUCAL eligibility, and the state recognized their PRUCAL eligibility status, and they're treating the DACA applicants exactly the same way. Okay? So there was precedence to doing this. Okay, so one of the issues that comes up when an immigrant is applying for any benefits, including the private coverage, including Healthy New York and some of the other private coverage that they may be eligible for through their jobs, is the fact that they're required to have a Social Security number. Or the way it's been interpreted for PRUCAL applicants who may not be eligible for a Social Security number based on the stage of their immigration application, what happens is the benefit granting agency has to give them a letter or some kind of proof requesting a Social Security be assigned for identification purposes only. That person, that immigrant, cannot go into Social Security alone and say, give me a letter. They won't say, and I've asked for a Social Security number, they won't do it. But if the Medicaid agency gives the person a letter, and it's a form letter that's attached to all of the State Department of Health materials for their workers, then the Social Security office is supposed to give them some kind of acknowledgement, either saying you're not eligible because, but just something so it shows that they tried to get one. Once the immigrant returns that letter to Medicaid, they're supposed to proceed with the application. Okay? It's messy. It's never pretty, I'll tell you, when people need to do that. It's just not pretty. All right, so Lanika, you asked about Child Health Plus. So in New York State, and again, New York State is very generous and inclusive with their children's coverage. There are states where not only are undocumented children left out, they're actually waiting lists for kids to get CHIP coverage, because CHIP is a block grant, unlike Medicaid, which is an entitlement. But in terms of talking about immigration status, it's most kids up to the age of 19. Undocumented children are eligible, and a non-immigrant child is not automatically eligible. So what's the difference here? So the next slide talks a little bit about how you distinguish between an undocumented child and a non-immigrant child. Remember that a non-immigrant child is a child that perhaps was born in another country and is here with their parents, but who entered with a visa that is temporary in nature and doesn't indicate an intent to remain. That makes it a non-immigrant visa. The three most common ones that you see around medical issues are up there: medical visas, tourist visas, and student visas. Okay? If that non-immigrant child cannot show proof that they are New York State residents, then the CHIP program may deny them coverage. And those cases sometimes trickle through. So how do you show proof? You have to show proof that either the parent is employed here, that the parent has a lease here, that there are school records for that child, or there's some kind of immunity, something that links the child to New York State. Pardon me, I'm losing my voice a little bit. So who are the groups that we've had problems with? We've seen problems sometimes with migrant workers that move with their kids. This has happened not in New York City, but upstate, where when the family is working its way through New York State, whenever it's apple picking time or whatever the harvest is, those kids may not be able to establish residency in New York State, and consequently the CHIP program may not accept them for coverage. Okay, those cases are few and far between, I'll tell you. Questions? Lanika, did I cover everything for you? Okay, I'm waiting to see if Lanika sends me. Okay, great. Okay, so the next slide.
Leonie Parker has a question.
Oh.
For DACA individuals currently enrolled in school, do they have to provide documentation of their enrollment, class schedule?
Okay, so is that a question about their Medicaid eligibility, or is that a question about their eligibility for DACA? Right, because to me it kind of sounds like it's a question about their eligibility for DACA, and I have to be honest with you, I just don't know. I haven't gone to one of Legal Aid's clinics yet. I'm going to go in a couple of weeks and help these kids apply, so I don't have the answer for that. Medicaid eligibility. Once they've filed the DACA application, they do not have to prove that they're living here. Remember, that's the standard for CHIP when you have to establish residency. Well, there's an issue for a non-immigrant and residency. Under DACA, once that individual has filed the application with USCIS, and when they've sent the check, and they can come to Medicaid with a copy of the application and a copy of the canceled check, or a copy of the notice of receipt from USCIS to saying that it's properly filed, that person can apply for Medicaid, Family Health Plus, and all the related programs. Okay, so here's just the bottom line about applicants that I just want to make sure all of you remember. This is not immigrant application rights, this is everybody. Applicants, and this should be true of every local district, of every FE, of every CBO FE that they go to. It should be true for the Open Enrollment Center. They have the right to be told about the programs that they might be qualified for. They have to be told clearly what the qualification is for these programs. They can ask for assistance to apply for the programs. They should be able to get an application, get an interview, and also get a written notice of decision which tells them whether or not the application was approved or denied. So the reason we raise this is that there has been, throughout the changes to immigration status for eligibility for Medicaid, which has really happened in the last 10 decades, there has been the problem of folks being turned away when they go to apply because a worker says, do you have a Social Security number? Oh, you don't, then you're not eligible for anything. Now, is it possible that that person isn't eligible for coverage? Maybe, but it's not the Social Security number, which is an indicator of what their immigration status is. And that's why we include the slide about applicant rights. If you hear of someone who is turned away and they can identify the location and reasonably identify the person that gave them that information, that is something that I want to know because I will report it to the State Department of Health or to the City Department, the Human Resources Administration, to make sure that they are training that worker to understand the rules a little bit better because they're hard. They're not easy. Okay, it's complicated stuff. It's easy for the people whose categories appear on the list, but it's hard for the people who don't have sort of obvious or clear eligibility. And so what do you do if you get an application that is denied? I'm sure all of you have been through CSS's wonderful trainings on fair hearings. You have a fair hearing right if you are a Medicaid or Family Health Plus recipient or if it's one of the Medicaid-related programs. I'll talk about CHIP in a second. You can request a state fair hearing. These are 4 different ways you can request it. Please note that if you request it via the internet or by fax, you must keep a copy of the printout that you get on the internet, and by faxing, you please keep a copy of the transmission report. In New York City, you can go in person and get a fair hearing in person. You can request it in person. The only reason I might suggest that someone do that is they give you the number right away, and then you can immediately request the evidence packet. If the person, it's easy for them to get around. So questions about applying for a fair hearing? For CHIP applicants, because it's not an entitlement program and so there's no fair hearing, right, you have to make your appeal or your complaint directly to the state. Okay? So moving on. So the bridge plan. So I'm sure everyone remembers what the bridge plan is. The acronym in the law is the Pre-Existing Condition Insurance Plan, which was created obviously under the federal health care reform. In New York State, it's called the Bridge Plan, and it's all administered by a managed care company called Emblem Health. Now, the standard for the pre-existing condition insurance plans is the standard that is going to be embraced throughout the DACA coverages, and the standard is what's called lawfully present. I'm sorry, I should have had it in quotations in the top 2. The takeaway here is that protocol analysis for Medicaid eligibility does not apply to the lawfully present standard. And that's why when we started talking, I said there's 2 areas of law that matter here, right? So you need to forget everything that we talked about, protocol analysis for Medicaid eligibility, because that does not apply to the bridge plan. And unfortunately, unless there's a change, it's not going to apply to the other federally subsidized programs that come down the line, the tax premium assistance and anything else that comes about. So what is lawfully present? There's a list that appears in all of the rules that are being issued. And if anyone wants the actual citations and wants copies, I'll send them to you. I didn't send out the 2 sections of the Federal Register or the letter to the CMS State Medicaid because it's complicated stuff. It's like that first slide I showed you with 100 things. And I really haven't figured out the best way to train on this yet, which is why I'm just giving you the basic idea, which is that lawfully present are the qualified aliens, and then there are 8 enumerated additional categories that largely overlap over many of the New York State protocol categories that include that the person has been granted employment authorization. And I'll give you a specific example there. We're not looking at knowledge and permission or acquiescence. Those folks that come in and want to apply with that woman, that grandmother, right, that daughter, the mother who wanted to apply with a copy of the adjustment of status petition and proof that it was received would not be eligible. Okay? So one of the enumerated categories is someone who is a pending temporary and protected status applicant who has already had their application processed to the point that they've been issued an employment authorization. Okay? So now if we were to look at, come on slide. I'm sorry, let me move ahead 1 second and I'll show you. Hold on, where's my ugly chart? Oh, here. So this is an excerpt from the documentation guide to citizenship and immigrant eligibility for health coverage in New York State. And if you look through here, you see persons granted deferred enforced departure, permanent non-immigrants pursuant to Public Law 99-239 with the Federated States of Micronesia and the Marshall Islands, persons granted TPS or applicants for TPS. This category kind of tracks what you see in these 8 additional categories for the bridge plan, okay? With the exception of the last one, which is that some documentation showing that USCIS has both knowledge and has either granted permission or acquiesced for those people, okay? This is complicated stuff, and as we get more experience with it, I'm confident that this will be easier to both train on and to learn, okay? Because it's just it's hard to follow. Questions? Hannah.
Yes, I do have a question, although it may be just that I don't know enough about how different you know, public health care programs are funded in New York or different public assistance programs. So, you know, cut me off if this is too basic, but I guess I'm kind of wondering about the scope of, so if I understand correctly, if a program is federally funded, or say a healthcare program, public health care program is federally funded, then PRUCOL kind of like PRUCOL, the standard for PRUCOL does not apply. Is that right? Like in New York?
If you are a PRUCOL immigrant, a federally funded program will not cover you.
Sorry, right. That's
okay.
So like that's why you were saying like
Correct.
bridge plan.
Correct.
And this is where maybe I just don't know enough about how programs are funded, but does the program, what if a program is partially federally funded? But
well, all of Medicaid is partially federally funded, right?
Okay.
Because you have it's called the FFP, which is the Federal Financial Participation. It's a certain rate that each state has negotiated with the federal government. And so Medicaid has an FFP, or a Federal Financial Participation. What happens for the PRUCOL immigrants is that you have coverage through state-only dollars. Okay, in the Child Health Plus program also, you have coverage for certain groups of people based on state-only dollars. And when we get to the chart again, I'll go over the different lines of it, and you'll see a code 0, and code 0, and it actually tells you what code 0 is PRUCOL, and then it also tells you whether or not there's federal financial participation.
So when the state is when the state on its own is funding the coverage for non-citizens, that's where PRUCOL could potentially be applicable, even when there's subsidized funding by the federal government.
Say it again.
I think
okay.
Yeah, I guess.
Okay. So, but it's an important point, which is that when a PRUCOL immigrant is covered by the Medicaid program, it's state-only dollars. We don't have federal financial participation there, which is why the rules are slightly different. Okay. Okay, so before I jump into figuring out what someone's immigration status is, do I have questions about what I just confused everyone on? Okay, wait, is that a question? Okay, someone is raising their hand. Okay, so Lily, your phone isn't hooked up, so we can't get you live. Do you want to type your question? Lily Resnick from Staten Island, I'm sorry to embarrass you. Okay, well, while we're waiting for Lily to either get on the phone or type her question, what I wanted to tell you, we're going to go over the most common records that people will bring to you to look at, or that the state will request for them to establish their eligibility. And in your new advocate guide, which I've been told you're going to receive in November at the intensive training, there is an updated chapter on immigration that was done by the wonderful and fantastic Barbara Wiener from Empire Justice Center. Now, in that section, I am assuming that she has included what she always has, which is actual photographs of these cards, and then we can go over them at the intensive training and show you where the code pops up. If for some reason that's not going to be included, I will scan in the ones that I have and share them with Drew, who will share them with everybody else. But again, I didn't want to kill you guys with paper, right? So Lily, can you get through to us, or we're going to move on? If you can get through to us, then I'll answer the question. Okay. Okay, so the permanent resident card. Permanent resident card, it means that you have a lawful permanent resident, and it is no longer green. It used to be green when it was old, okay? That does not mean that you automatically get Medicaid or Family Health Plus in New York. It means you still have to prove your income, your resources, and all of the other great things you need to prove to be eligible for Medicaid and Family Health Plus. Now, lawful permanent resident status does not expire, but the card does have an expiration date. I don't know why they do that. You know, maybe they want to get a new fee. Maybe they want to push people into naturalization. I don't know why that happens, but the application should not be denied if the person's card is no longer active. The program is supposed to help them apply for a new one. Sometimes people don't apply, mostly because out of ignorance, but oftentimes it's because it's expensive and it's, you know, you have to deal with a lot of paperwork.
So Lily, Lily got her question through.
Okay.
Can a pregnant woman have the bridge plan with a visa?
Depends on the visa.
At one time, I remember the bridge plan did accept pre-call status. Has that recently changed?
I only went by what I read in the law and the regulations and all the recent stuff that's come out. The original July 30th, 2010 doesn't talk about pre-call status. It talks about lawfully residing. So if in New York State they were doing it, it was under some other theory that unfortunately I'm not familiar with.
Okay.
Okay. I only know what I read at the federal level, and then what I looked at, you know, when I was investigating their material.
Okay.
So I can't answer the question.
Okay.
Do you remember
We had a
It was Sam that told me.
we had a case recently where I called a bridge plan. A person with a student visa present in New York City, and his wife joined him with the spouse of a student.
Yeah.
That she's pregnant. They could not get a bridge plan because they said she was not.
But see, you know, that's something that I would like to look at,
Yeah.
right? Because if she entered and was eligible based on where she was in the process of immigration, if she was eligible for employment authorization, then she may fit the criteria for lawfully residing.
She was only here as a
Temporary.
spouse of a student. He was here for 1 year. He had a 1 year visa to study at Columbia.
Yeah.
She joined.
So she was not. That's non-immigrant.
Yes, exactly.
That's non-immigrant.
Yeah.
That's
For
non-immigrant.
PCAP, they said she could apply for.
Right.
And
They don't look to immigration status with PCAP, and they probably didn't press too hard on whether or not she was a resident.
Yeah.
Right.
So Lily says that she submitted a bridge plan application on September 10th of this year. The bridge plan is delaying the approval.
Okay, but it's hard for me, Lily, to know if what they're doing is correct or incorrect under the lawfully residing criteria without knowing exactly what visa she was able to enter on. The list of visas that are eligible, you know, there's a long list of sections that come up, and so I would need to know the section under which she's eligible for the visa so that we could see if she's eligible. Because what a visa is, let's talk about what a visa is, right? What do people think a visa is? I'm bothering the people in the room. What's a visa?
authorization to be in the country for a number of reasons?
Okay, so what it is it's authorization or permission to enter and be in the country. It's not permission to stay in the country. It's a different thing. So when someone has a visa, it means that they were able to gain admission to the country, but it doesn't mean that they're necessarily able to remain. Okay? So we don't know based on, without knowing the category of visa and under what code of the Immigration and Naturalization Act that person was admitted here, and if they meet the protocol criteria or the lawfully residing criteria for the bridge plan. Okay? So moving on. All right.
Is a person's visa like the type of visa that they have named on the I-94 card?
Yeah, usually. So we'll get there. So, oh yeah, and so green cards aren't green anymore. Okay, I'm sorry, I'm repeating myself. It's only the, are they green again? Well, no, they have all kinds of security features embossed in them, and so they're hard to replicate and copy. Yeah, they're multicolored, right. And then here again, it explains that they have to process the application even if the green card is expired, because the status does not expire. You can lose your permanent resident status, but that's an immigration class, not a Medicaid class, okay? All right, so the I-94 is the arrival or departure record. That's what you get when you first come into the United States. Now, sometimes it's a little white card that's stuck in your passport, and sometimes it's actually a stamp that goes into your passport. The stamp has the date that you were admitted and then the code. The code, more often than not, correlates to the basis for admission for the visa that you're entering under, okay? Sometimes the I-94 also has a date where your permission to enter ends. There's a great deal of confusion for immigrants sometimes because someone will have a business visa or a tourist visa that allows them to enter for almost 10 years, but they're only admitted for a shorter period of time. Now, this is where we're pretending we're immigration lawyers and where we're not being public health insurance advocates, okay? So again, that's for the immigration class, not for the who's eligible for public health insurance and the federal programs. So employment authorization card is also another document that you'll see a lot of the numbers are up there. And these are cards, literally cards, and they identify the category under which that person's immigration status applies. So, you know, a lot of those all appear under Section 274 of the CFR, of the Code of Federal Regulations, and each code relates to a different basis to apply. And so, for example, 274A.12C18 is for someone who has been granted an order of supervision. Someone who has 274A12C24 is someone who applied under the Family Unity, okay? Now, why am I telling you this? I'm telling you this because when you are trying to help someone who has been denied or is going in, what you're going to want to do, I'm jumping ahead again, is actually go to this document, and I have the full document saved and minimized. This is the full title is Documentation Guide to Citizenship, Immigrant Eligibility for Health Coverage in New York State. It's a GIS that was issued in 2008, and this is the one that's being updated to reflect the Haitian TPS people, and then the DACA kids, okay? But if you look here in the column that says documentation, you see I-688B, and then it talks about the Code of Federal Regulations. So what I would do for someone that's going in and you're concerned that they're going to have trouble with it is I would actually highlight this section of the desk guide and send it in with the applicant, okay? Because this is their own document. They know this document. They're going to be like, oh, wait, yeah, this person it might be eligible, or this person is eligible. I have to ask the person who knows this stuff better than I do, okay? So here we go, all right? Now, remember I said that you can get an employment authorization card sometimes. You're allowed to work legally if you're here as a student, or if you're here on, there's the H visas, which are the visas for folks that have specialized or technical skills, and they're sponsored by companies. It's a complicated process. They get a labor certification from the local Department of Labor so that they can enter and take a job from, you know, an American citizen. That's not my editorial, that's other people's editorials, but you can get employment authorization, but you're not going to be eligible for Medicaid because you're a non-immigrant, okay? So the employment authorization card alone is not evidence that the person is eligible for Medicaid or Family Health Plus unless the code matches with one of the codes in the documentation guide. Okay, so what else do you have, right? We talked about the concept of permission or acquiescence, right? When you get something back from USCIS or you get a card from them, they've basically granted you permission. But when you haven't gotten something back yet, that's when you're trying to make the case for eligibility based on acquiescence. And so you need to look at other documentation that they may have. So this is where we need to look at a copy of the application that was filed and attach proof that it was received, whether it's the postcard or the canceled check. That's Ayaz's case that he asked about, the mother of either a lawful permanent resident or a citizen who sponsored the mom to be here. this is the section of the desk guide that goes through the acquiescence categories. Okay, and here's where I wanted to show. So category refers to the category of immigration. Documentation are the typical documents that you receive. Okay, the WMS, I don't know what ACI stands for. WMS is the State Department of Office and Temporary Disability. All of the public benefit programs use WMS, and the code for PRUCAL is 0. And here you see federal financial participation. No, these folks are covered through state-only Medicaid. Okay, and here you also have the requirement that the local district has to give the immigrant a letter so that they can go to Social Security Administration and ask for a Social Security number. Okay, now this excerpt is one section of a 12-page document. I did not print that out. I did not bring it to you. It's a link at the back of at the second to last slide in the PowerPoint, because this should get updated on a regular basis, and so that's why I don't want to give you a hard copy. You should always go to the one that's available, unless it's the same month. Please go and look at what the State Department has posted, okay? So here's some examples. Here we go. She is applying to adjust her status to be a lawful permanent resident, and the son has sponsored her, and she hasn't been approved yet, but she has something that says that she wins. She's eligible, okay? This is the same one we've talked about quite a bit. Here's another one. So this applicant has a receipt. It's actually a notice of receipt from USCIS, and a letter from the immigration explaining that an application has been filed. A petition has been filed for her to adjust status or get a green card. And then she has a letter from USCIS saying you can come in. What we have here is proof that something was filed with USCIS and an acknowledgement they got it, right? Her application may take a very long time to approve the adjustment of status form, but during that period of time, she is at PRUCAL eligible for Medicaid and Family Health Plus. We have a question.
Madeline Henriquez. I'm going to unmute you, Madeline.
Hi, Madeline.
Hello, everyone. It's really not a question. I just wanted some clarification. So even if they don't have an actual status, like with immigration, as long as there's some kind of confirmation that they know that immigration has, they know that they're here in the country, that's pretty much what would make them PRUCAL and eligible for Medicaid and Family Health Plus. No?
That's actually not right. An important part here is that a very important fact here is that person has some basis on which to remain here. Remember that the abbreviation PRUCAL is permanently residing under color of law. Okay, there has to be a reason why the person can stay. It can't just be a certified letter sent to USCIS saying, hey, I want to stay here because my cousin Steffi King lives here and she's a citizen. That's not adequate. Okay, the person has to have a basis for getting what's called an immigration benefit. So they have to fit one of the immigration categories to apply and then have proof that it was filed.
Okay, thank you.
Yeah.
Okay. And we have a question from Leonie Parker. Is there a difference between a visa authorization period and the authorization to stay period? If someone has an active visa but their authorization to stay is expired, are they undocumented?
Yes. Again, I'm not an immigration lawyer, but my understanding is that that's when the person has violated the term of their visa, right? Because I was admitted for 6 months and I stayed longer than 6 months. Okay. Okay, so here we have someone who entered legally, right? Whenever you have an I-94 arrival and departure in your own name and with your own passport, that means that you were inspected at a border, okay? This person was allowed into the country and was given an F. Now, F code links to foreign students and their dependents. It's an F code in the Immigration and Naturalization Act, okay? This is not Medicaid law, this is immigration law. The next thing that the client brings you is a letter saying that this person has been brought into, in addition, has a petition to be a non-immigrant worker. That means that they can work here legally. is here on a temporary student visa, but we can't say that because it's a non-immigrant visa and it's a non-immigrant worker application and a temporary student visa, does that sound like we're meeting the permanent requirement under PRUCAL? No. And so this person does not have a good PRUCAL standing to apply for full Medicaid or Family Health Plus. But remember that this person is always eligible for Medicaid coverage for the treatment of an emergency medical condition if they're low income enough. And if Mr. D were a female and got pregnant, then he would be eligible for PCAP. Okay? Remember in the beginning when I was talking about strategy, always start with what kind of health care services does this person need? Because there may be a program that meets the needs for the individual but and isn't full Medicaid. Okay? Hannah.
I just want to make sure that I'm not getting between the different, I think these are different standards. Someone who is like a resident of New York, although not an LPR, like for, I think, charity care purposes, I was reading this, right?
There's a little bit of confusion because the term residence is also used in most benefits to indicate that it's the location where you live, but it also does have a meaning when you talk about lawful permanent residence for immigration purposes. They're two different things. They become relevant with CHIP because we need to see that a child is a resident of the state even though they might have a non-immigrant visa.
Okay, great.
So it does get confusing,
Great.
but remember always sometimes we're talking about immigration, sometimes we're talking about Medicaid eligibility or charity care eligibility.
Definitely, but I can be a non-immigrant resident.
Correct. Cool. But yeah, right, exactly. Okay, why are we stuck? Hello. Okay, before I move on to the second part of the training, which is talking about the things that worry our clients when they apply for public health insurance or seek medical care in general because they're immigrants. Do I have any questions relating to eligibility questions? And I'm wondering, John, can you help me get to the desk guide so I can show it to folks before we come into this section? Katie.
Is the assumption that Healthy New York, because it's a New York funded health insurance or subsidized health insurance program, that the PRUCAL category will apply to health insurance?
There's no immigration requirement for Healthy New York.
At all? Okay.
At all. Drew asked me this yesterday, and I was like, Healthy New York, oh my God, I haven't thought about it in years, like in years. You know, we never get Healthy New York clients, right? So I looked over everything. There's no immigration criteria. The issue that I think may pop up for folks is they do ask for a Social Security number. Now, my guess is that they ask for the Social Security number for what purpose? Just for identification. So that may at some point be an issue, but because I have zero experience with Healthy New York, right, because most of our clients at Legal Aid, because they're so low income, we're able to get them eligible for Medicaid or the kids for Child Health Plus, or if they're disabled, you know, we work with them.
Pretty low income.
We don't get people applying for it. I don't know what it is. We just don't get a lot of those calls. Okay, so what you see here is the full ugly 12-page beast. And what it does is it goes in categories. So first you have a category for U.S. citizens, and then as you go down the pages, thank you, John, you'll see, so these are all the different ways that someone becomes a citizen, a group that's collectively naturalized. I have no idea what that means. If you keep going, we now get to the category 2 is the qualified aliens. This is the list that comes straight out of the federal law. And here you have category, documentation that you can produce, what the code is in WMS, and you see the big yes in the fourth column. That means that there's full federal financial participation for these folks because they're qualified aliens. And then if you keep going, we're going to get to the last category, which is PRUCAL. Here we go, category 3. All right, so if you look through here, right, you will see all the different categories under which, now the category refers to the immigration application that the person has filed and or been approved for. And in every single one of the fourth columns here, there is no federal financial participation for these folks. Okay? So, and this is a long, this is a long section as well. And it goes into pretty much a lot of detail about the different types. And then you have the non-immigrants, and it goes through the different visas that are typically non-immigrant visas, and then they talk about undocumented people. Okay? So if you work with a lot of immigrants, it's good to have this handy. And again, what I would do if someone's going in to apply for something and you're sure that your local district is going to have a problem with it, my recommendation is that you print out the relevant page, highlight the section that applies to your client, and send them in. Now, we see typically problems sometimes around the U visas. The U visa applicants are people that have witnessed a crime and have filed a petition with certification from law enforcement or a judge saying that they're a cooperating witness. It's a high standard to get that. It's really difficult to put those applications together, and oftentimes what we see with those is that because there isn't a high volume, I guess, sometimes the local districts don't know what to do with them and they send them back. So if you were to get something like that, one thing you could do is call us at Legal Aid, and we'd be happy to help you with it. But you can also send them back or request a fair hearing with, again, the highlighted section saying, look, this client has met all this criteria. Here's the application that was filed. Here's the certification from law enforcement. Here's the notice of receipt. And so she or he should be eligible for Medicaid. We see that used in a lot of instances where there's domestic violence in either a married couple or an unmarried couple where the abuser is not necessarily the petitioner, right? Because the women that are generally women that are being abused by their spouses who are also their petitioners have all kinds of ways that they can apply. How can we get a copy of the desk guide? It's a link in the second to last slide. You need to cut and paste it into your browser, and you will get to the desk guide. Okay? So moving, if we can jump back. So without any other questions, I'm going to jump into immigration concerns, immigrant concerns. Okay? So now these fall into two big buckets. Some of them have to do with how receiving the benefit is going to impact your pending immigration application, or a sponsor. When you're sponsored by a family member, how it's going to affect a sponsor. Okay? The other bucket of concerns or problems are folks who are afraid about being reported to USCIS because they fear being deported if their presence in this country comes to light with the federal government. So we're going to talk first. So people are really frightened. People are frightened because, if they're undocumented, because some of them live lives completely beneath the radar and never try to protect themselves. And oftentimes they're trying to get health coverage for an emergency, for an injury, for something really, really serious, and so but they're terrified. But the other reason, so you need to ask these questions. A lot of what we see also is a lot of street law or just really bad advice from people that say, oh my goodness, no, if you get Medicaid, you're going to be a public charge and you're never going to be able to be a lawful permanent resident. Or if you get Medicaid, they're going to sue your sponsor and you're going to, really there's a lot of bad information out there. And so that's why I wanted to include these slides. I'm happy to talk with any client you have that might have one of these problems because these conversations can be a little tricky. What I am always guided by is that it is, at the end of the day, it's the client's choice. And I never withhold information. I always tell them what the actual consequences might be so that then they can make a decision. Because it's their decision, it's not ours, even if they really need the coverage. And even though we know that the state Medicaid program would authorize them and let them get coverage, it's their choice, right? So you need to tell them what may or may not happen, okay? Most people won't be affected by it. That's the bottom line. And there's bad information out there. People confuse Medicaid with receiving cash assistance or public assistance or food stamps. They lump them all together. And that's a huge mistake. For someone who's receiving just Medicaid, there are exceptions to public charge concerns. So I'm sorry, this is a summary of what I just said. The three big areas are public charge, sponsor deeming and liability, and then verification of status and reporting. The first two are the bucket of problems about affecting your immigration application and or your sponsor in family sponsorship, and the last one is the one that people are afraid of who are undocumented. So public charge is actually a term that is used by the Federal Immigration Authority that talks about immigrants who enter legally but somehow become dependent on public benefits while they're living here. They can actually, when the person is applying to adjust status from an immigrant to a lawful permanent resident, they can use public charge to deny the individual that opportunity. Now, it is clearly articulated in a number of documents from the USCIS that the use of health benefits like Medicaid coverage for the treatment of an emergency condition, Family Health Plus, Child Health Plus, prenatal care, vaccinations, should not make an immigrant a public charge, okay, with two exceptions. One is when Medicaid is used for long-term institutionalization, and the second one is if Medicaid is used for HIV or AIDS-related care. Okay, let's talk about this separately. Medicaid for long-term institutionalization, what does that mean? That does not mean that if I'm in a bad car accident and I get sent to rehabilitation for a couple of months to regain use of my leg, my arm, whatever the issue is, that is not long-term institutionalization. What that contemplates is someone who has been relegated to a nursing home with no anticipation of ever returning to the community, right? They are not, public charge shouldn't apply to someone who's gotten hurt, and we expect should at some point be back on their feet and be able to care for themselves, okay? Now, one thing related to this, I want everyone to think about, have you ever, I know there's medical repatriations that happen in various states. It hasn't really happened here. But we don't see USCIS going to deport or remove someone, some old person or some very disabled person from a nursing home, right? I mean, that doesn't happen. The USCIS has higher priority. So, but again, that refers to someone who goes into a nursing home and isn't expected to come out. Okay. Now, the second one relates to the next slide, which was there used to be a ban on infectious. It was a ground for inadmissibility. Someone who was otherwise eligible to be admitted to the country and/or adjust their status, if they had an infectious disease and they specifically enumerated HIV/AIDS, there was a ban to allowing that person be admitted to the country. Now, this ban was lifted, okay? But under public charge, they may still consider the HIV positive or AIDS status and use of those programs as an indication that you're not healthy enough to work, okay? My recommendation there is that you should not be advising people in that position. They need to go to an immigration expert in HIV/AIDS issues, not even just an immigration expert. There's a number of organizations that have expertise on this. GMHC has expertise on this. One of the links that I have in the second to last slide is to a group called Immigration Equality that specializes in immigrant issues as it relates to LGBTQ individuals and also individuals with HIV/AIDS, and it provides an excellent history of the ban when it was lifted and what the continuing consequences are. The takeaway here is, please, if you have someone who is HIV positive and is struggling with these questions, they have to speak to an expert in HIV immigration issues. Please, 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 because you don't want to get them into trouble, okay? All right, so when does USCIS make the public charge determination? They do it at one of two times. They'll do it when the person is applying to enter the United States and or when that person is adjusting his or her status to become a lawful permanent resident. Once I am a green card holder, once I have my lawful permanent resident status, if I apply for Medicaid, Child Plus, food stamps, whatever I'm eligible for, they don't ever make a public charge determination for citizenship, okay? And this is what I was talking about, bad street law. People think that this problem stays with them, the public charge, and that they can't get any kind of benefit until they're a citizen. That's not true. Once you are a legal permanent resident and you are lawfully eligible for whatever the program is, you can use it and you don't have to be worried about public charge. Okay. Yes, there's a question.
Alexandra just wanted to say thank you for saying immigration expert in HIV/AIDS.
Okay. They're all coming to you, Alexandra, so be happy. So what does this mean in terms of cases, right? So what this means in terms of cases is we would, like, not even on a regular basis, but like once every other year, we would get a case for someone who had a visa to enter and had been in this country in the past on either a student visa or a tourist visa or a visitor visa, and while they were here, they got prenatal care through the PCAP program or the whatever we're supposed to call now, pregnancy Medicaid. And at the airport, they're told that they can't enter because they're a public charge. That's one type of case that we've seen. But that doesn't happen all the time. That seems to happen, really, it's like once every other year we get a crazy case like that, okay? And then the second one is when the person is trying to adjust his or her status to become a lawful permanent resident. And again, this seems to happen on an episodic basis. It seems like sometimes the adjustment officers that are the ones that are making the decision about whether or not someone can go from being an applicant for lawful permanent resident to being a lawful permanent resident. And it's a long application process and it's expensive. It's an adjustment officer who has the discretion to make these types of inquiries, right? And it seems to be episodic. I don't know if it's when there's a change of staff, when there's a change of attitude, when when there's news about people being here and using benefits that aren't eligible. I don't entirely understand why it happens, but what we do see happen, and it's a problem, is that they will often collapse together all of the programs. So they'll say, oh, Medicaid is public assistance. It is not public assistance, okay? Public assistance is cash assistance, and the income eligibility criteria is different. Let's set aside the fact that USCIS has gone on paper, on the record, to say that using Medicaid and the related programs do not make you a public charge. The income eligibility criteria are different. To get public assistance and to get food stamps, I'm not expert on this. Steffi knows it better than I do. Your income has to be much lower than it would be for most of the Medicaid programs. And so what this is really oftentimes is just some healthy immigrant animus or some ignorance on the part of the adjustment officer that's doing it. Now, sometimes we've had these cases that have come to us, and I'm moving to the next slide because it's relevant, because the affidavit of support that was filed on behalf of a family-based application suggests that the person has income above this 125% of the federal poverty line. And then the Medicaid application or the cash assistance application suggests that the person has less. That's a different reason for the adjustment officer to be making an inquiry, right? In that case, the adjustment officer is saying, hey, wait, something's not right here. Can this person be supported here by the sponsor, or can they not be? So that's a different issue than the agency making a mistake in terms of how they're applying the standards. So these types of cases are few and far between, and if you ever get one, just call us up and we'll troubleshoot with you. We'll pull in our immigration unit because they're the ones that, this is about the immigration application and the immigration status. It's not about the Medicaid status. But again, these cases are few and far between with public charge, but they do pop up, every other year, okay? We're due. We haven't had one in a while, so there's got to be a ripple now. All right, so the affidavit of support. The affidavit of support is a form that is signed by the immigrant sponsor. Now, I guess I should explain what a sponsor is, right? To apply to become an immigrant in this country, there are various different categories of application. And I think the audio is out? One of the most common form of application are what are called the family-based petition. In that instance, the individual who is the sponsor, or petitioner is the person who lives here and has some kind of immigration status, whether a lawful permanent resident or a citizen. The beneficiary is the immigrant that is being sponsored to enter the country. That petitioner and or a spouse of the petitioner signs something that's called the Affidavit of Support. It's Form I-864. Now, why do I mention the actual form number? Because I haven't mentioned it with the other ones. It's because when this form started being used, the impact on the sponsor changes, right? The prior Affidavit of Support that was used for family-based petitions was not considered a legally binding contract. The I-864, which is the one that has been used since December 17, 1997, is considered a binding and enforceable contract, which means that the sponsor is liable for providing support and care for the individual. All right? Now, the Affidavit of Support, in that document, the sponsor is promising or swearing that they can support themselves and their legally dependent family members and the sponsor at or above 125% of the federal poverty line. So going back to Ayaz's family and that son or daughter who brought mama home to live with him or her, we're assuming that he made enough money to support himself, any spouse that he might have, any children that he might have, and his mother at or above this level, okay? And it's all based on family size. So when do you use it? It's used for the family-based petitions, and it's used in one type of family employment petition, only those where the relative is being, where the company, the relative who's sponsoring the person also owns 5% of the company. So the family-owned businesses, right? The classic one is the Chinese restaurant, okay? and I'm not trying to do stereotypical or ethnic sort of stereotyping, it's the Chinese food restaurant or the Italian restaurant. Those are the only ones where they're required. It is not required when you have a self-petitioning battered spouse or child, a qualified widow or widower, an applicant who can show that they worked legally for 40 quarters prior to applying. 40 quarters is roughly 10 years of work. You're not going to see a lot of those, okay? And then there's some of the humanitarian categories, which are the parolees, the students, and the diversity immigrants. They have a different affidavit of support, okay? And then folks who originally applied for adjustment of status, for admission to become lawful permanent residents before December 17th of 1997 also use the other form, which is not considered enforceable. So do they enforce affidavits of support against sponsors when the person is applying for Medicaid? And the answer is no, not yet. Now, I say not yet because in the New York State law and the New York State Medicaid program, they do include all of the necessary language and notices about sponsor liability. It's all in there. But they've always said that they're not contemplating enforcing it. They want people to use coverage. They want people to get coverage, but it's on the books. You know, so it would not be accurate to tell someone there's nothing to worry about. The reality is that right now there's nothing to worry about. The other reality is that if the state were to ask immigrants to have their sponsors pay back, there is no doubt that there would be a lot of investigation and support in the advocacy community to look at the process, to understand that there's good for hearing rights, and also to make sure that the poverty level of the sponsor is considered in any decision to seek repayment from the sponsor. Now that is actually the way that it works in the food stamp program. They look to see the overall poverty level of the sponsor before they will actually pursue repayment on food stamps. So there's no reason to think that it would be different in the Medicaid program. But right now you can absolutely say that there's no sponsor liability currently being used by the New York State Medicaid program. So let me back up. So what is sponsor deeming? What sponsor deeming contemplates is the idea that the immigrant actually has access to the sponsor's income. And so when you're looking at that individual's eligibility, the person comes to you and says, I work, I make X amount of dollars a month, and I have 2 children, right? Under sponsor deeming, the next question would be, oh, how much does your sponsor make? And they would assume that that money is accessible to you. The state doesn't do that for Medicaid, okay? So that's something that someone may ask you about, and you can just say they're not doing it now because that's in fact the case. The more difficult conversation is the sponsor liability question. Okay, questions before I go on? Okay, so people are experts on deeming and liability. Okay, so deeming also has some exclusions. There's no sponsor deeming for the list here. You have the refugees, the asylees, folks that are sponsored by an organization, and battered immigrants who are qualified aliens. Those are folks that apply under the VAWA rules, which are pretty complicated and which I'm embarrassed to say I'm not an expert on. So I can't tell you much detail with that. But again, it doesn't apply to everyone. Okay. The other categories are the humanitarian applicants, not the family-based applicants. So remember, that's one of the first questions. If it isn't a family-based petition, then sponsor deeming and sponsor liability is not an issue because they didn't sign that I-864. Okay, so here you go. Okay. Oh, and this is an important point. If the sponsor has not paid or is ignoring requests for repayment or cooperating, that will not take away the immigrant's, the beneficiary immigrant's ability to adjust his or her status. Okay? So just to be really clear, if the sponsor can't pay, won't pay, doesn't want to have anything to do with it, that won't mean that the person who was the sponsored beneficiary is not going to be able to adjust his or her status. Okay? And then the other thing that when people have asked me about this, one fact that I always tell them is that the immigrant can actually pay any liability that's imposed as well. It doesn't have to be the sponsor, right, as long as the debt is paid. But again, these are all theoretical conversations because they're not doing it in New York for Medicaid. Okay? All right. So the next bucket are the ones where people are afraid because in applying for Medicaid, even for prenatal care or for a Medicaid for the treatment of an emergency status, they are afraid that somehow the federal government will learn that they are here and try to initiate removal proceedings. So verification of status refers to the obligation of the State Department of Health and the local district to verify the individual's immigration status when they're applying for Medicaid and FIP. You can tell someone who's applying for CHIPS, Medicaid for prenatal care, or emergency Medicaid, that they are not required to verify his or her status. They're just noted as being not having satisfactory immigration status. End of story. Okay. Reporting. So the specific question is, will they contact when someone's applying for Medicaid? And they might, right? They might if the person presents expired documentation, or if for some reason the eligibility worker suspects that there is a problem. Okay, so you know, this is where I said don't be an immigration lawyer. If you have any reason to be concerned, if the client is concerned, if the papers look weird, if it's got someone else's name, like use your judgment. If the papers really seem off, then that person needs to talk to an immigration specialist to make sure that they're not going to get themselves into trouble. Okay, we've had people come who have been lawful permanent residents for 25 years, and in interviewing them, they say those magic words when we ask, have you ever been, this is not related to Medicaid, but to other inquiries that we're doing, have you ever been arrested? And suddenly we learn that the person not only was arrested, but incarcerated for more than a year, and all of our alarms go off, because there may be a deportation order against that person, right? And they have no idea. Right, because they were arrested when they were young, they did something dumb, they were in prison for over a year. The critical piece is over a year. They were in prison for over a year, and you know, there might be a deportation order against them. And if they were to go apply for Medicaid, is it likely that Medicaid is going to like hunt down the you know, if the card is good, they probably won't even look. But you've got to be concerned, okay? But again, you're not immigration lawyers, okay? There are resources out there for low-income people, knowledgeable people. There's a lot of outreach sites that Legal Aid's Immigration Law Unit has with Single Stop. I can share that list with Drew if people want to refer people. It's not something to be afraid of, but it's something to be aware of, okay? And if there's ever a judgment call, you're not sure about something, you can email these to us at Legal Aid and we'll take a look. Obviously, if you're emailing us any client documents, you need to get all kinds of permissions, right? So what's the duty of report versus verification of status? Verification of status, again, is the obligation of the agency to check when they doubt that the papers are kosher, okay? Duty to report means, does anyone who works for New York State Department of Health have an obligation to drop a dime on someone that they think is not an immigrant or that they know is an undocumented immigrant? And New York State's policy is clearly and resoundingly no, okay? The applications have, the two applications that are typically used, the Access New York Healthcare and Growing Up Healthy applications are confidential. It actually recites all of that on the application form. The one requirement is that unless you have knowledge that there's a final order of deportation against someone, the agency doesn't have to report someone. Okay? Now, is this ever a problem? We once heard of a horrible case coming out of Erie County, Buffalo, where, and this is how it happened. There was an undocumented couple. They were in a terrific, terrible accident. They had to be airlifted to some sort of tertiary level hospital in the Erie County, Buffalo area, and they couldn't find anyone that could speak the language of the couple. They were from China, so they contacted USCIS to help them find an interpreter. And lo and behold, that family, you know, the couple was very badly injured, but they found themselves, you know, they came to the attention of the USCIS. But it's those kinds of stories that you hear in New York. You don't hear the kinds of stories that you hear, unfortunately, coming out of Arizona, where now the police are allowed to inspect your immigration documents. New York State, just in case anyone was confused, is not Arizona. Okay, so does that mean that there are pockets where there's animus to immigrants? I know that there are areas where the police would love to be able to drop dimes on people. It's not going to happen with their Medicaid applications, though. Okay? And I see there's a bunch of questions.
It's actually just one question
Okay.
from David Pazinski. I have a 30-year-old acquaintance who has not had legal status since his teens. He has no insurance, works very part-time, probably Medicaid eligible salary, has made a public statement well covered about his status. Should I tell him he can apply?
You need to talk to an immigration lawyer. I'm not an immigration lawyer, right? But David, you need to go back to the slide, not here, but look back to the slide for deferred action for childhood applicants. When did he get here? I mean, if he was here before 2007 and he's over, you say he's 30 years old, maybe he's eligible for DACA, but he needs to hustle. I don't know when his 31st birthday is. He really needs to move. And if he entered before, I think it's 2007, June 15th, 2007, and he was here continuously until June 15th of 2012, maybe he can apply for DACA and actually correct his status. But you would need to refer him to an immigration expert, okay? But he shouldn't be reported, okay, by the Medicaid program. That's the bottom line here. Okay, other questions about reporting? Okay, so I'm sorry that my resources for the uninsured are only New York City based. I don't know what happens upstate, but I would love if someone either wants to chime in and or maybe Empire Justice can send around what folks are advised to do upstate. The reason I have this here right after reporting is that the New York City Health and Hospital Corporation has, again, there's an executive order from the mayor saying that the city agencies will not report people. And HHC has been very, very publicly open to everyone, including undocumented people, to come in and get the care that they need, and they do not report people. They do everything they can to register people for the subsidized program so that they can get paid, which is why when you go to one of the public hospitals, if they ask you to apply, they may ask you for a Social Security number. They may ask you what your immigration status is. It's not because they're trying to collect information to drop a dime on someone. They're collecting information to see if they can get reimbursement from someone who can pay when the person is very low income. But they will not turn the person away, and they will not report. Okay?
Mandy Robinson wants to know, who are the immigration experts that we should be referring these people to?
So in New York City, I can send the list of the Robin Hood outreach sites that Legal Aid's immigration unit provides support to, and the way it works is that you call the organization and find out when they can give you an appointment. As you can imagine, it does take time to get through. I don't know what the resources are upstate. I'm sorry.
Yeah, that was an upstate agency. They're close to Canada, actually.
Oh, Mandy, I'm sorry. I don't know what's available upstate. You know what I might do is go on to Law Help and hit the immigration button, and they may have some resources, maybe affiliated with the law school where they'll do some of the screening. I don't know what else there might be, Mandy. I'm happy to, I have my number. I'll give everyone my number. But Mandy, if you want to call me in the office, we can try to put our heads together and see if we can find someone upstate that can help you. Okay? And then the next question from David is if we should share the presentation with the refugee resettlement agencies. Absolutely. There is something called refugee medical assistance, which is not included in this training. And what it is it's a short-term benefit for recent refugees, and there are some limitations to it. I haven't spoke on it in quite some time, I mean before 2004, so I don't know if the rules have changed, but it's called refugee medical assistance, and it's something like 8 months. It's not that long, and there are some exclusions, I think, also in terms of what will be covered. But so David, if you were to share it with the refugee assistance communities, I think it's good because it might help people transition to other coverage when the refugee medical assistance ends. But there should be some thought given to making sure they check in on the refugee medical assistance, although they probably know it because it's administered, I think, through the resettlement agencies. And then last thing is links. All right, so generally, to get more information on immigrant access, you can go to, up until the new advocate guide is up and available, you can go to New York Health Access. That's the first link. That's a website that Legal Aid co-sponsors with Self-Help and Empire Justice. And if you go to the page and look on the left-hand side, there's a menu, and one of the bullets is immigrants. Okay? And then this link to the New York State Health State, the Health State the New York State Health Department has a lot of information about eligibility generally, but they also have good documentation on the immigrant stuff. Specifically, if you want to look at the desk guide, you see first you have the memo. The first link under the second bullet is the memo that describes the document, and the second link that says APP PDF is actually the document. This 2008 desk guide is the current document that's available. You can also look in the Medicaid reference guide. It literally has pieces of the document included. This is the document that they told me yesterday that they're updating to reflect not only the DACA kids, but also the Haitian TPS category. Okay, and then finally, the immigration equality link here is specifically about the HIV ban. And if you want general information about the impact of being HIV positive and trying to immigrate, this is a good place to go because they have a lot of excellent materials. Okay, so to wrap up. You can send clients to us either as CHA agencies. You can refer them to us, and we will give advice and/or represent them. We can't represent people that are super high income or that don't live in New York anymore, but we can certainly give them advice. And so clients, if you just want to refer a client directly, they can get to us two ways. They can call our helpline. We have both a downstate and upstate number. We're only open Tuesday mornings, unfortunately, because there's too many people that need our help. And also people in New York City, they can come see us at the PFAIR table. PFAIR is, Steffi, what is PFAIR?
PFAIR is an on-site legal help desk in the main waiting room of the welfare hearing in Brooklyn.
Right, and a year ago, the Medicaid program joined the public assistance hearings at the Brooklyn site, and Legal Aid has the helpline unit has established a Medicaid-specific PFAIR hours on Tuesdays from 12 to 3. You can also email us at the advocate email. Please, that's not for clients, not because we don't want to help clients, but because we check it on a daily basis. But if there's an emergency, we prefer that people be calling us, because if they call my helpline and it's a day where we're not open, it goes to the operator and they find me. Okay, I spend an hour to 2 hours a day with people that are desperate for help who aren't our clients. So they find me. So it's better to give them the phone line than to give them the email. Okay? Question? Who's sick of hearing my voice?
A couple of additional resources, too. Lily mentioned lawhelp.org, which is really helpful in finding probably an immigration expert in their area. Typically, there are income limits. If your client does not qualify with the income limits, a fabulous resource for New York State residents is New York Bar Association, and then if you live in the city, the New York City Bar Association, and they'll take general information from you about what your issue is and give you a qualified attorney that has experience in that area, and you get a reference number, and it's $35 for a half-hour consultation. But what we've heard is that a lot of lawyers will spend a lot more time with you for only the $35. So that may be a good resource. The other thing is that, as you all very well know and are familiar with, we hope, in the portal, there are resource guides per major metropolitan area in New York. So that would cover the uninsured folks who want to use sliding scale clinics or hospitals that have sliding scale programs, and those are available on the portal. So for the upstate folks, for some resources for uninsured, that's a good place to look.
So you know what, I realized that I forgot something that was a special request from the downstate agencies from the last monthly meeting. They had asked for information or clarification about the process of getting an undocumented immigrant or an immigrant who has otherwise unsatisfactory immigration status coverage through the certification for the treatment of an emergency medical condition. And one of the documents that I sent around as attachment is, it's not a new form because it's from 2010, but it is the form. There used to be an upstate form and a downstate form, but since May of 2010, this is the form that has to be filled out by the doctor so that that undocumented immigrants' application for Medicaid will be accepted in this limited category. I want to point out just two things for you related to this. The first is, and this was the big change, they included a release, an authorization to release medical information that the client is required to sign before this is submitted. The way that this is supposed to appear, if you ever help someone fill it out, and it's in the memo that came with it, which is why I included the memo, not just the form, it has to be a double-sided print for them to accept this, because they want to make sure that the authorization to release medical records is in fact signed with the certification. Okay? If this doesn't make sense, just take a second and read over the memo. It's a two-page memo. It's plain English, and I really do think it's very clear about this issue of having the authorization, having this form printed out as a two-sided piece of paper with the authorization signed on the back. That's one thing. And then the other question is that you can use this form to authorize more than one emergency period. Okay, so let's talk about it. I applied for Medicaid for the treatment of an emergency condition. I am otherwise eligible for Medicaid. That means I've proven income, resources, residency, and what my category is, right? So then I need the doctor to say, well, in fact, this was an emergency. I might be authorized for longer than 2 months or 3 months at a time, but the doctor needs to certify the emergency for up to 90 days at a time. Okay? Now, it sounds confusing because it is confusing. We're assuming at this point that the person has established that they're eligible for otherwise eligible for Medicaid, and then the doctor has to complete this form saying this person was treated you can fill this out 4 times one form. You can authorize certify 4 periods on one form. So the first one could be from yesterday to the end of this week. And then they know that I have to come back to make sure they get the stitches out or to make sure the infection is going away or to make sure, I don't know, you can fill in the blanks. They want to make sure the bone is setting correctly. So then they certify, I'm sorry, I'm mixing up authorize and certification. They certify that the emergency continues. That's what they're certifying. It's not that there's a new emergency. It's that the condition that you're coming back for is related to the initial emergency. That's period 2, okay? And so on. You can sort of follow through. Now, when would you have multiple certification periods? What's the biggest one you guys can get? Cancer, right? Cancer would be one where you have a repeating certification period because the person needs to come back on a monthly or semi-monthly basis for several months to have chemo or radiation. Okay, so I'm thinking, Alexandra, that maybe this is where your client is being forced to recertify every 2 months. Maybe there's something wrong with his certification. So Alexandra was talking to us about a case at the monthly meeting where the person is being asked to do a full-on Medicaid recertification every 2 months, and we were trying to figure out how that could be. And this is someone who has less than satisfactory immigration status for full Medicaid. So maybe it's with this certification period as opposed to the overall authorization for Medicaid that there's a problem. And so now I'm really ready to stop talking, so I wonder if there are questions. So Alexandra says she's going to share the gist. What I'm wondering, Alexandra, is if I appreciate that your client may not want to share documents with third parties, but maybe you could share some of the notices and or some of his underlying documentation redacted, take out the name, take out the identifying information, and I can look at it also and just see if by looking at it I say, oh, here's the mistake. You know, clearly it sounds like they're making him or her jump through a lot more hoops than he should have to, or she should have to. Okay, so that was my mini certification of an emergency medical condition. Well, thanks to all of you. My number, if people want to call me, is 212-577-3928. Again, 212-577-3928. I'm usually running around like a crazy person, so the other thing you can do is you can email me. My email, which I always answer because they give me a BlackBerry at work. So it's LK-Vamonde. If you miss the spelling, it's the very first slide. It's LKVAAMONDE at legal-aid.org. Okay? Thank you.